Welcome to another edition of PN Lawyers Facebook Live Friday. I am Taso Pardalis, and in the last few weeks, we have heard a lot about what's been going on with contracts and leases and force majeure provisions and PPP and business loans, all important issues, but we have to make sure we don't forget to talk about the non-business side of COVID's effects, how it has affected families and couples and roommates who have been forced to be confined together by the Stay Home, Save Lives directive in place in New York City right now. We here at PN have always handled cases involving domestic violence and child support and custody, and they have always been treated very seriously by us here because most of the time, not always, but most of the time, there's children involved. And as you guys know, 2 days after Governor Cuomo issued Executive Order 202.8, what the media has called the New York State on Pause law, which shut down all non-essential businesses, the New York courts also shut down for everything except for emergencies. So let me talk to you about how that has affected families, starting with child support. So let's get into an example. Okay, the biological parents are separated. The parent who does not live with the child, the non-custodial parent, pays child support every month, which is set by the court. And that child support has to be paid in full at the same time every month. No excuses. Another example, a bad breakup. The biological parents hate each other. The parent who pays the child support always pays on time, always. If the deadline is approaching and the money has not been received by the parent who lives with the child, a nasty text usually follows, warning that if the payment is even 1 day late, they are going to court. If the payment is late, can the parent run to court and file papers asking the judge to hold the late paying parent in contempt of court? The answer is yes, absolutely, of course. If the payment is received a few days late, the tardy parent is usually not going to be punished, but they will have to take time off from work and appear in court. And they might want to have an attorney there with them. And so now they also have to pay for an attorney. Things like this happen all the time in family court, every day. But what if the paying parent is injured or becomes sick or they lose their job? And what if they even send a text to the parent who has custody of the child, but the parent does not respond? 1 month goes by. 2 months go by. No child support is paid. And one day, there's a knock on the door of the out-of-work parent. It's the city sheriff. They're there to serve papers, ordering them to appear in family court because they're in contempt of a court order to pay child support. By the time they have to appear in court, 3 months have gone by, and they still have not been able to make payments for child support. They go to the court, and they try to explain to the judge that they just lost their job and they could not find work, and judge, here's the proof of all the places I tried to get a job. But the judge just looks at them and asks, did you file a petition for a downward modification? A downward what, judge? No, I didn't. I don't know how. I don't even know what that is. And if I can't pay money for my kid, how am I supposed to afford a lawyer, judge? The judge usually just looks at the parent with no expression. The judge then tells the parent that they are entering a judgment for arrears from the time they stop paying up to the day of the hearing. And then the judge says, go down to the clerk's office and fill out a form for what is called the downward modification order of the child support. The date that document is filed, that stops the arrears from adding up. So, as soon as the paying parent lost their job or got sick or whatever, the first thing they should have done was run to the court and file a petition for a downward modification so that the receiving parent could not get them in trouble. Guys, in normal times, pre-COVID, that's the option for someone who loses their job or gets sick or for whatever reason can't pay. But what about now? So many people have lost their jobs. There wasn't even a court to run to after March 22nd. There wasn't even a petition clerk on duty at the family court, and there still isn't today. And as crazy as it sounds, child support is not considered an emergency. All of those arrears for everyone are just adding up now, plus interest. It's just unbelievable. So, meanwhile, unemployment rates and unemployment insurance claim have soared to ridiculous levels, okay? For the week ending March 21st, 2020, the New York State Department of Labor received 1,734,100 calls and 2,270,300 web hits. Even though things are starting to loosen up, on April 8th, 2020, individual judges in courts throughout the state began addressing the following matters remotely. 1, conferencing pending cases. 2, deciding fully submitted motions. And 3, addressing discovery disputes. But no new non-essential matters may be filed until further notice. What does this mean? Well, child support petitions, including downward modifications, and initial support petitions are listed as non-essential. So if parents are not able to file a support petition, they will be denied retroactive relief to the date of the basis for filing the petition. Lost your job? Too bad, pay me. Couldn't file a petition to cut your losses? Too bad, pay me. You might ask, can't the courts take into consideration that the courts were closed? The answer is no. No, they cannot. So while Governor Cuomo has issued more than 20 executive orders from March 7th, 2020 to date, each addressing various COVID-19 legal anomalies and modifying or suspending various state laws, no order has been issued to afford relief to New Yorkers and families impacted by the examples I just gave you. Under the laws as they stand now, courts are without authority to alter child support obligations in these circumstances. How are we here handling this problem? Well, the first thing we do is we attempt to appeal to the reason and the decency of the opposing attorney or the other parent who's receiving the payments. If that fails, we prepare legal papers that have to be filed, even though we cannot file them yet. We do formally serve it on the other party and their lawyer. We want to place them on notice, of what we're going to ask the court to do. And in the model I gave to you earlier, we want to inform the court that the payments that we have been making cannot be paid because of extraordinary circumstances, which there is no doubt that COVID-19 is causing extraordinary circumstances. And the first day the court allows us to file the petitions, we are there and we will be ready. So the papers must include a formal financial disclosure affidavit with documentation evidencing the job loss and receipt of any unemployment benefits, as well as a listing of all job search efforts. So what we're asking our clients and what you should do is keep track of any online applications for jobs and create a log of all the contacts that you made in the job search. We're also recommending to clients that if they can, they pay something, anything, rather than nothing for now. Paying something, even a small amount, shows the court that we're not just trying to take advantage of the circumstances. But doing nothing is just about the worst thing anyone can do in this type of situation. And guys, the same problem arises in the realm of child custody and visitation. So in custody and visitation, in these circumstances, is it unreasonable for a parent to prevent the child from leaving their home to visit with the non-custodial parent? I mean, that's the question. Usually, the remedy is to run to family court and file a petition for the violation of a visitation order or a custody order. Although this may be an emergency for you, it is not an emergency in the eyes of the courts or the governor. So what do? Well, we try to encourage a civil dialogue, and we try to create as many compromises as we can. We try to arrange for more video or telemeeting time between the parent and the child. We try to bargain for more vacation time later, anything. We try for anything, really. And if that fails, well, just like with the child support order, we prepare a petition, we serve it on the other side, or the other parent, the other lawyer, and we wait for the courts to come out of their coma. For now, that's all we can do. One thing to keep in mind is that if the child support custody or if the child support custody order or the visitation orders are from a divorce proceeding that was in the Supreme Court, you can right now file a motion electronically for relief. So if the custody or the visitation or the child support was as a result of a Supreme Court divorce hearing, you can file in the Supreme Court electronically right now. And so there is something there for those of you that ended up in Supreme Court for a divorce. Finally, domestic violence. You know, because of the forced closed quarters, we are seeing an exponential increase in complaints around domestic violence. Thankfully, these cases are treated as essential in New York, and the courts are open and prepared for these. So for new child protective petitions, they are accepted Monday through Friday from 9 a.m. to 2 p.m. And any child protective petitions that are filed after 2 p.m. will be heard immediately the next morning at 9 a.m. For family offense petitions, they can be filed anytime Monday through Friday from 9 a.m. to 4 p.m. And for additional information, anyone can contact the New York City Family Court by email at nyfcinquiry@nycourts.gov or by telephone at 646-386-5299. If you are a victim or someone in your family is a victim, please just call 911 immediately. Then call the Family Court hotline, 646-386-5299. If you do not know what to do, or you're not sure, or you've been arrested, you can just call us at any time. Our office number is 212-213-8511. My cell phone number is 347-400-8194. Okay, that's it for today, guys. I'll hang on for a minute in case anybody has any questions. What if the child support wasn't court ordered, but a term of the divorce agreement instead? Would the out-of-work parent still have to file for a downward modification with the court? The answer is yes, but if the divorce agreement was filed in the divorce proceeding in the Supreme Court of whichever county we're speaking about, you can actually electronically file for a modification of the order there right now. You don't have to wait for everything to open up. Okay, guys, that's it for today. I'll see you guys next week. Thanks for joining.